I like to say that, when you think about a soccer game, we think that there are strict rules and the players play soccer within those rules. I'm saying coding capital operates in a way in which the players themselves change the rules of the game while the game is in process. And now the players themselves don't have the sophistication, they know what they want, but they typically have a lawyer on their side. And so the lawyers are the masters of the code, because the lawyers know where the hard boundaries of the law are. They also know how to play with the boundaries or know the gray areas. What is often forgotten is actually that capitalism existed before democracies, and that the law that we're using to code capital is the same law that existed prior to the democratization of society. But the point that I want to make is when you think about the amount of wealth that has been accumulated, this amount of wealth could not be created without corporations, without trusts, without being able to evade taxes, without protecting your assets and making them durable over time. I think our legal system works because most people believe in the authority of the law. It is basically a system of trust. Now, if some then use the rules in a highly mechanistic and utilitarian fashion and push the limits of these rules because they don't care about the underlying normative values, what they do care about is pushing the limits to make money. The question is, why should I play by the rules if nobody else does? If you bend the rules, why should I be bound by them? Our global capitalists today are roving bandits because they can actually roam the globe and grab assets, and the state backs that because the state makes it possible for them to pick and choose different legal systems, move around to different jurisdictions.
Katharina PISTOR, bonjour.
Hello.
Alors, je suis très heureux de vous recevoir sur la chaîne YouTube du site Élucid. Alors, vous êtes juriste, vous êtes une professeure de droit renommée à l'Université de New York et vous avez publié un livre qui s'appelle « Le Code du capital » qui a été très remarqué, qui a obtenu plusieurs récompenses, car comme son sous-titre l'indique, il explique comment la loi fabrique la richesse capitaliste et les inégalités. Alors, il vient tout juste d'être traduit en français aux éditions du Seuil, dans la collection d'ailleurs que dirige Jacques Généreux, que nous avons reçu il y a quelques mois. Alors, je précise que vous êtes allemande et que vous vivez aux États-Unis depuis plusieurs décennies. Et donc, nous allons mener cet entretien en anglais. Alors donc, ce livre traite d'un aspect très important. Il explique comment la loi fait prospérer le capital. Vous développez longuement cette idée-là, mais pour commencer, je vais vous demander quelle est votre définition du capital?
Yeah, capital, as Karl Marx already explained, is a social relation. And so it's not just a factor of production, which is the classic definition in economics in particular. Labor and capital are the two factors of production. But it's a social relationship, and it's a relationship that is mediated, in my view, through the state and through its legal system. Because in order to put anything into some process of production, you have to have title to it. You have to have a right to do so. And so I'm basically saying capital is any object, any promise to future payment, for example, or any idea that is coded in law and that has certain legal attributes that give it a comparative advantage over ordinary assets.
Oui, vous expliquez justement que le capital finalement se compose de deux choses, finalement d'un bien et d'un code juridique. Est-ce que vous pouvez expliquer, s'il vous plaît?
Yeah, I'm basically saying take any object, give me a piece of land, give me a promise to future payment, or give me an idea, an innovation. And with the right legal coding, I can flip it into a capital asset. So take the example of land. Land is just a piece of dirt, right? You can graze your cattle, you can maybe build a house, or you can harvest fruit from the land. But in order to extract monetary value, to make money from the land, you have to be able to sell it. So you have to have a right to that land. Or you want to take a mortgage. You have to have a right to take a mortgage, and the creditor then gets a right to the land. Take an innovation, it's maybe even clearer. When we have an innovation, everybody could just copy it, unless you get a patent, which is a legal monopoly right. Then only you can use it for a period of time, for which the monopoly is valid, and then only you can extract the value from this particular legal monopoly. So it's always the combination of something, and I call it an asset, but it could be just an idea. It could be could be a piece of land. It can be machinery. It can be just a promise to future payment. Our financial system is all about promises to future payment. But if I promise you to give you €1 million tomorrow, nobody will buy that from you, unless it's a financial asset that can be, if needed, enforced against me.
Alors, vous expliquez que, justement, les biens que vous citez ont changé au fil des années, mais que, par contre, les outils juridiques qui permettent de les coder, ce que vous appelez les modules, sont restés relativement constants. Est-ce que vous pourriez nous présenter, justement, ces modules?
Yeah, I think this is one of the most interesting findings for me, actually, to think how constant the legal devices have been. So, even when you take one of the most complex financial instruments, like say a derivative, and you unpack its legal structure, what you find is what I call the modules of the Code of Capital. You find property rights, you find guarantees or collateral law, you find, of course, contract law, you find very often a common law trust device or corporate law. And then we can add some other features such as bankruptcy law. So I'm basically saying these devices, you can trace them back to hundreds of years, if not more. Property rights were known in Roman times, of course. But modern property rights are a little bit more of recent origin. But they have changed constant. We have first coded land in these modules of the Code of Capital, property rights, guarantees, contracts, corporate law, trust law, bankruptcy law. But once the technique was established, we could do the same with financial promises, promises to future payment. We can do the same with intellectual property rights. We call them property rights, patents or trademarks or copyrights, for example. And of course, we do it all the time with financial assets. We create new types of financial assets with these 5 modules of the Code of Capital.
Mais finalement, qui a créé ce code? Quels en sont les maîtres?
So the code is actually both a practice and a legally recognized practice. So when you think about the Code civil in France, 1804, it was a codification by the legislature, but it was based on legal practices that had existed prior to the code. So we have the legislature involved in offering the modules of the Code of Capital, which are part of our private law. So it's not administrative law, it's not state regulation. It's private law that is made available to private parties to organize their relations with one another. Horizontal relations, largely, with one another. But then you can become playful with the civil code. You have contract there, you have property rights there. And so how you combine and recombine the modules of the Code of Capital that are part of the legal system, and how you can push the limits of these coding devices, that's really how you create capital. You're not just staying within the limits, but you're trying to push the boundaries of the game, right? I like to say that, when you think about a soccer game, we think that there are strict rules and the players play soccer within those rules. I'm saying coding capital operates in a way in which the players themselves change the rules of the game while the game is in process, right? And now the players themselves don't have the sophistication, they know what they want, but they typically have a lawyer on their side. And so the lawyers are the masters of the code, because the lawyers know where the hard boundaries of the law are. They also know how to play with the boundaries or know the gray areas where they can push and say, I think this is legal, and maybe somebody will challenge us, but we probably will win. And maybe nobody will challenge us, and then we just do what we want to do. And so this is basically where a lot of power comes in, a lot of knowledge comes in, a lot of sophistication also comes in. But the lawyers, in the end, are the masters of the Code of Capital, of the legal Code of Capital.
Cette chaîne YouTube ne vit que grâce à vos abonnements à notre site. Si vous aimez notre travail, vous pouvez nous soutenir en vous abonnant sur www.élucide.media. Vous y retrouverez de nombreux contenus exclusifs pour aiguiser votre esprit critique. Vous êtes nombreux à vous être mobilisés pour aider Élucide. Nous nous rapprochons de l'objectif de 6000 abonnés nécessaires à assurer notre survie. Toute l'équipe vous remercie pour vos précieuses contributions.
Alors, il y a un autre point important. Vous expliquez évidemment que le code du capital, c'est un code légal. Donc, il nécessite la loi, c'est-à-dire qu'il nécessite un État puissant pour le soutenir. Quel est justement ce rôle de l'État? Est-ce que vous pourriez l'illustrer?
Yes, the state most important function is to commit to enforce the rights that have been coded by the lawyers for their clients. So the state basically makes available its private law, property rights contract law, and basically says, if you take these things in a reasonable way and you create new transactions, promises in contracts, we will enforce these rights. And we will enforce them not necessarily only between the two parties, let's say, to a contract, but when it comes to property rights, for example, we are enforcing these against the world, against anybody. And that gives these instruments, these promises, the power to be traded especially in anonymous markets where people don't know each other and can't build their relations on trust. What they trust is the enforceability of a legal instrument. And that's why we need the authority of the state that backs the legal commitments that have been made in private law.
Alors justement, pour rendre tout ça plus concret, vous développez un exemple qui est assez sidérant, qui concerne les Mayas au Belize. Est-ce que vous pourriez nous présenter ce qui leur est arrivé?
Yeah, so, it's interesting always to ask, where do property rights come from? And the standard answer for lawyers is, of course, the state defines property rights, and only the rights that the state has defined can be recognized as property rights. And I give the example of the Maya in Belize to show how we can also, through the state, through the courts, create new types of property rights. So the Maya in Belize are indigenous people that have lived on that territory for centuries. Then there was colonization, and different powers colonized Belize, most recently the Brits. And the crown conquered the territory. But the question came up at some point, did they actually also alter whatever rights the Maya have had? And of course, the Maya didn't have an English kind of property rights regime. They had land use practices, but patterns of land use practices. Once Belize became independent, happened before, of course, as well, but it continued in that process, the Belize government handed out licenses to mining companies to mine the land of the Maya, basically claiming that this land belonged to the state, they could do whatever, and they just allowed companies to mine the land. The Maya tried to sue. In the first round, they were not heard by the Belize court, so they went to the Inter-American Human Rights Committee, later on came back to the Belize courts, and tried to make the case that they had a property right in their land. It wasn't registered. It was never written, nowhere written that the land was owned by the Maya, but they said, we do have a property right. And they went to the Belize Constitution, and the Constitution says, we want to respect the diversity of our people. We want to protect also the Maya, the indigenous people of this country. But then it says what many constitutions say, property rights are protected by the Constitution. But what is a property right? And this, the Belize Supreme Court had to decide at some point. And they, in the end, sided with the Maya and said, property rights is not only, English property right, but property rights could also be collective land use practices. And so established that under the Belize law, the Maya actually did have a property right. Now that's a good story, it's a nice story, it's a positive story. On the negative side, the Belize government did not respect these property rights, but continued to hand out licenses to mining companies. And here's, of course, the duality of the state. It protects property rights, but if the state itself doesn't protect the property rights of some, it's very hard to go against the state.
Oui, donc en conclusion, en fait, les Mayas ont gagné devant la justice, mais l'État n'a pas respecté. Donc, ce qui montre que sans État, en fait, il n'y a pas de droit de propriété.
Yeah, exactly. Without the state respecting these rights and enforcing them against itself, even, and of course against third parties, you don't have a property right.
Alors, dernier aspect théorique, vous expliquez justement que les modules dont on vient de parler donnent 4 caractéristiques essentielles au capital, la priorité, la durabilité, l'universalité et la convertibilité. Est-ce que vous pourriez nous expliquer justement ce que sont ces caractéristiques fondamentales pour le capital?
Yeah. So when I say you have to have a legal code to create capital, of course I have to explain what the coding devices do, what the modules do with a simple asset, with a piece of land, with an idea, with a promise. And what I'm arguing is that they create certain privileges or rights, comparative rights that other assets do not have. So you can have a piece of land, but you don't own it, then you cannot have priority rights to this land. You can't exclude others from it, and you can't say that you yourself will get all the profits that one can generate from the land. So I'm saying priority right, give the holders of capital assets a right to be first in line to get anything. And it's sometimes very useful to think about a bankruptcy scenario or insolvency when a debtor no longer has enough assets to pay everybody back. That's the kind of the asset test for who has the best rights. Because if you own something that the debtor has in possession, you have basically given your car to a friend and the friend goes into bankruptcy, you can take the car out and all the other creditors have to stand aside, right? So priority is really important. The second is durability. And durability basically means that we're trying to protect assets so that they can grow over time by excluding too many creditors from having access to these assets. So we can shift some assets to another subsidiary, or we can create a trust vehicle. So we can protect the assets in the trust from certain types of creditors. We're using legal devices to shield assets from too many creditors, which means that they then can incubate, they can grow over time. Universality is what I said before. The state is enforcing the commitments that are made in law, and it's enforcing these commitments against the world if necessary. And then last but not least, for our global financial system, or for the financial capitalism in particular, convertibility is important, because convertibility is the way in which financial assets attain durability. Because with financial assets, you just don't want to hold them, you want to trade them. And you also want to have an option in times of financial crisis to convert them into real money, into state money. So we know that when there's a financial crisis, the investors always run for the exit. And what does it mean? When they run for the exit, they want to turn their private assets now into money, because only money can protect the nominal value of what they have gained in the past. Then they sit on the money a little bit and then they want to invest again into private assets where they can really make money. But this convertibility option is critical for financial assets.
Alors bon, tout ceci, ça semble assez théorique, mais en fait, il y a des conséquences pratiques qui sont extrêmement importantes. Vous avez d'ailleurs une jolie phrase dans votre livre, puisque vous expliquez que des fortunes peuvent se constituer ou disparaître en modifiant le codage d'un bien, en privant un autre de certains modules ou en greffant ces modules sur un nouveau bien. Pourriez nous expliquer justement comment on arrive à faire ou à défaire des fortunes?
Yeah, let's start with the simplest asset like land, right? Before land was put into private ownership, enclosed, and then you got legal title over it, it was shared by many others, which basically meant that we had certain governance rules about who could use the land when, but nobody could extract the full value for themselves. Only once we had allocated private property rights to individual owners could they say, it's my land, I exclude you, and I can extract these assets. So that's just the first example. Another example is you can also sometimes pull certain protections from an asset. And this is, again, a good example is England in the late 19th century, because the landowners, those that had received property rights to the land, also wanted to mortgage the land, but they didn't want to lose the land for their family, for the future generations. They wanted to keep the land, over time, even though they had mortgaged it to creditors. So they used a legal device, it's called an entail, works a little bit like a trust, to basically say that the head of the family is not the real owner of the land, but he's only a life tenant. He only holds the land for future generations. That's a legal construct they use to code the land as something not quite as property rights. And that meant basically that the creditors could not seize all the land if the head of the family could not pay his debt. And so at some point, of course, the system had to collapse because they had given credit, they wouldn't pay back, they couldn't seize the land to satisfy the creditors. And there was a big crisis in England in the 1870s. After that, the Parliament enacted a law which basically said, from now on, we will treat the life tenants as real owners, which means the creditors can seize all the land. That resulted in a massive reallocation of land in England. In my vocabulary, they basically took out durability. They basically stripped durability from these legal constructs that protected the land for future families and said it's just property now. And that basically meant that land was much less protected, much less useful as a source of wealth for these families.
Alors justement, il y a des conséquences très concrètes sur la répartition des fortunes et donc sur les inégalités. C'est un point qui est au cœur de votre livre, de vos travaux en général. Et d'ailleurs, votre livre s'ouvre sur la description d'une courbe qui est assez célèbre, qui s'appelle la courbe de l'éléphant. Donc on la voit ici, elle représente la croissance qu'il y a eu entre 1980 et 2020 de l'ensemble des revenus de la population mondiale, c'est bien mondial. Et donc on voit cette forme assez particulière que je vais vous demander de commenter, avec une petite précision à la fin. Il y a un énorme zoom sur ce qui se passe entre les 99% et les 99,999% les plus riches qu'on voit sur ce graphe.
Yeah, what I'm basically trying to explain using these data, which of course economists have put together, is that these riches that the top 1% or even the top 10% have, that these riches could not exist without the code of capital. Because when you break it down and you think about how this wealth is composed, what it's made of, then you'll see financial assets. You can also see urban real estate. You see all these different types of assets that are used to produce private wealth are actually coded in capital. So I'm basically saying, yes, of course, there might be skills that people have. They might have better luck in doing business. But without having a legal code, which is a social resource, it's a legal system that they use to create these riches, they could not amass these riches, keep them over time, inherit them to future generations, and protect them from others. They need the state and its law to do that.
Donc on voit qu'il y a une croissance relativement élevée chez les personnes les plus pauvres sur la planète, mais on voit justement qu'il y a une décroissance après assez brutale et qui correspond en fait aux personnes qui ont des bas revenus ou des classes moyennes des pays riches qui, eux, ont connu une croissance beaucoup plus limitée. Pourquoi ?
Yeah, I believe that the lower and medium income families and households just don't have the kind of legal protections to protect themselves from economic downturns. So we have economic ups and downs all the time for various reasons. The question is whether you can protect your wealth and your assets in times that are bad and where assets decline. And I think the rich, with the right lawyers at their side, can easily reallocate assets or protect them against downturn, or they can convert their financial assets in state money before it is too late, whereas most households just barely get by. And if they can't pay their mortgage, they typically are being evicted. Certainly in the United States, they are being evicted, right? Whereas the bigger asset holders, they know how to protect this themselves, or financial intermediaries get a helping hand from the state. So I think there's a major differentiation in access to law to protect yourself, to have an insurance during times of crisis. If you don't have this, you're exposed to the downturns of economic cycles, and you can see especially the lower middle class being exposed to these kind of downturns.
Mais justement, quand on voit ce genre d'inégalité qui commence à ressembler à celle qu'il pouvait y avoir même avant la Révolution, comment on peut encore parler de démocratie quand on voit ça, d'autant que, comme vous le soulignez, en plus, c'était pas vraiment le plan initial, c'était pas ce qui était censé arriver quand même, cette augmentation des inégalités quand on a complètement dérégulé dans les années 80.
Yeah, I think the idea of democracy is, of course, that we govern ourselves through law and that we do this in a way that is conducive or helpful to all, that we basically create an environment for human flourishing of all members of our society in democracy. What is often forgotten is actually that capitalism existed before democracies, and that the law that we're using to code capital is the same law that existed prior to the democratization of societies and is still part of our legal systems today. So we basically incorporated a system that helps differentiate assets among people into the democratic constitutional project. So we have public law and private law. And now we can use the private law to try to get around constraints that are imposed by public law, legislation that is democratically legitimated, but we can use to wiggle around. And then the state has to come back and try to cabin this again. So this is a little bit of a cat and mouse game that we're playing all the time. And of course, it's not conducive to the idea of collective self-governance. If some can use the same law that we use to govern ourselves in principle, to try to get out of the legal constraints that society tries to impose on all in order to make life possible in a peaceful and fairly egalitarian fashion for all.
Alors au final, c'est la loi qui décide finalement comment la richesse va être distribuée. Mais finalement, on peut se demander, mais qui décide de la façon dont la richesse va être distribuée?
Yeah, I think the first decision is made, of course, by asset holders who want to protect their interest in certain ways, but then they need the lawyers to be able to code their interest in the modules of the Code of Capital, as I explained before. So, of course, there is the state behind that. The state has basically endorsed the private law. It has codified the private law in the Code Civil or in other statutes. So the state is behind that, but the state does not control every decision. The state comes in only once in a while when somebody challenges the coding practices of the private parties. This could be another private party which says this is not right, or I can't be bound by this, I will not pay my debt, or something like that. Or it could be a regulator that says this is illegal. But it has to be challenged because in private law, we give the benefit of the doubt to the private parties and their lawyers who use the law to code their own private interest. So it is a combination of different actors. In theory, the state could come back and say, no, we don't like this, we will correct this. But there are a couple of problems with this. First of all, the state very often doesn't know because private contracts are made by lawyers in their offices, and they're not publicized, they're private contracts. Even sort of new types of property rights to financial assets are created in transactional law and are partly disclosed, but very often not fully understood. The second point is that the legislatures are relatively slow to respond because there are political institutions, and they're meant to be political. They operate through consensus, they have to debate, they just take time. In the meantime, private interests can find another lawyer and say, let's just move these assets somewhere else where they're protected from the tax authorities or where I can have a better advantage over somebody else. So we're playing a game that is a little bit unequal because of the very structure, the very legal structure of our institutions. The state structure on the one hand and the structure for creating private law and private interests in the law on the other hand.
Alors, en théorie, la loi est censée être au service du peuple, mais vous expliquez qu'en réalité, en fait, cette loi, le droit, a été mis fermement au service du capital, donc des plus riches. Comment justement cette modification historique a eu lieu? Comment est-ce que la loi a été mise au service des plus riches?
I think it's important to understand that private law, by design, helps private actors to organize their own affairs amongst themselves. And I think that's, in principle, a good thing because it allows people to be actors and to write their own life stories and to engage with other people. Also to adapt the law over time in a relatively decentralized fashion. So in a market economy in particular, in a dynamic economic development, things change all the time. The legislators are too slow to be on top of this. So we want to have a system that adapts over time in a decentralized fashion. But on the downside of the system, we can also have lawyers who are trying to push the limits of existing legal institutions to benefit their clients. Because the law is so flexible, private law is so flexible, we can use property rights and reinterpret them. We can use contracts to create better rights for one party than the other. Now, the other might consent, but very often the other party doesn't have a choice but to consent in order to get what you want. An employee or user of a digital platform never clicks disagree because then you can't get access to this particular platform. So the idea that we have formal equality under the law, but highly unequal allocation of resources, which is reinforced through the law, means that in fact, those who have better resources can hire the better lawyers, can create new types of assets and create new rights in the law that benefit them rather than others. And they use the state and the enforcement powers of the state to protect their rights. So we're using essentially, again, a social resource to create private wealth and then use, again, the coercive powers of the state to protect that private wealth. And we all do this under the mantle of a democratic constitutional order.
Alors, on va illustrer un peu plus en détail, de façon concrète, ce que vous avez dit. Vous en avez parlé rapidement tout à l'heure. J'aimerais bien qu'on parle finalement du bien le plus ancien, du bien historique, qui est la terre. son histoire et sa privatisation est extrêmement intéressante, non seulement en termes d'histoire, mais surtout, on va voir que le mécanisme est toujours à l'œuvre aujourd'hui sur d'autres biens. Donc, il faut bien le comprendre avec cet exemple qu'on appelle les enclosures. Alors, c'est vrai que si on prend une terre aujourd'hui, eh bien, forcément, soit on l'a acheté à quelqu'un, soit alors sur un héritage, on nous l'a donné. Donc, ça vient de quelqu'un, et ce quelqu'un, lui aussi, il a acheté ou il a hérité. Mais donc, on peut remonter, mais on ne va pas remonter très loin, puisqu'au Moyen-Âge, il y a un moment où la terre n'appartenait à personne, et donc il y a eu un moment où il y a une personne qui est devenue propriétaire d'une terre qu'il n'a eu de personne puisqu'elle était publique. Donc, est-ce que vous pouvez nous expliquer ce qui s'est passé avec ces enclosures?
Yeah, I think recent historical research in England in particular has shown that the process of enclosing the land, which basically means turning the land into private property rights, has taken a long period of time and started much earlier than people have thought. So most people had earlier focused on the big legislation in the 18th century that enclosed, in fact, only a small portion of the land. Most of the land was enclosed by the landlords asserting for themselves at some point the right to exclude the commoners whenever they wanted. So there had been for centuries certain land use practices. At some point you open the fields and the commoners can graze their cattle. And at some point you close it again and maybe the landlord can grow some crops there. And the landlords realized that they could make more money by using the land for grazing sheep for themselves, so they can put the wool into the emerging factories, or they could grow cash crops. So they built hedges and they built fences and said, no, you can't come back to the commoners. And so the commoners went back and they broke the fences and they broke the hedges and they tried to plow over the crops because they wanted to graze their cattle. It was a life decision, of course, for them as well. In the end, the courts had to decide the issue. So you can do this in a violent struggle, but they actually went to court. And the court cases went back and forth for some time. It all started in the early 16th century, maybe even a little earlier. But over the course of about 100 years or 150 years, the courts by and large sided with the landlords. And the landlords made what sounds like a legal argument. They said, we have seniority. We have the better rights. Our ancestors have always been in this land, and they only granted the commoners access at some point, but they had always had the right to take back the land for themselves, and that's what we're doing. That argument won in the end, and whether it's true or not, nobody can prove. There were no land registries at the time. There were not really documents that could prove that, but courts were persuaded by the landlords. The landlords, I think, had a better chance to persuade the courts because it was all a written process and the commoners were not literate. So they had to have a scribe or something who would transcribe their interest to make it legible for a court to decide these issues. But that's how land enclosure worked in England over a process of about 150, 200 years.
Donc en résumé, on est bien dans le cas où au Moyen-Âge, quelqu'un a vu un terrain qui avant était à tout le monde et puis s'est dit non, en fait, c'est à moi. Donc ça, c'est ce que vous venez de nous expliquer. Cette terre, elle devient privée. Mais évidemment, il y a des réactions. Et vous avez une jolie expression dans votre livre. Vous dites, une fois qu'on a fait ça, il faut arriver à protéger le butin. Qu'est-ce qui s'est passé et comment ils ont réussi à protéger le butin?
Yeah, there has, of course, always been protests against the enclosure of land because people became landless, right? If you can't graze your cattle, if you can't use the land anymore to produce your own crops, you have to find employment elsewhere. In the end, as we know, many of the former commoners migrated into the city and they became the proletariat for developing industrialization, right? So there was a major social transformation that took place at the time. But the first reaction was to protest and to go back to the land and cut down the trees or to find fruit and just to survive. There were, of course, also some criminal acts, but the landlords were very worried about this, about the protests and about the opposition to their rights. So they lobbied for legal protection. And there was the Black Act that was enacted in England, which made it a capital offense, punishable by death, to trespass on property and take what is not yours. So that just shows you how you can also use the state not only for creating private property rights, but also using criminal law to enforce the private property rights that had been created in a rather murky way, one might say, than by the force of law, and including capital punishment.
Alors, après les terres est venu le temps des entreprises et vous expliquez que c'est un des modules les plus importants du Code du capital, en particulier grâce à son ingénuité. Qu'est-ce que ça a apporté, l'entreprise?
Yeah, it's the enterprise or the company, but it's really the corporate form. So it's the legal form of the enterprise, and the two are not identical. There's some overlap. We very often think that a corporation is a single business unit, but what I try to explain in the book is that you can also use the same integrated business and use hundreds, if not thousands, of legal devices, corporate law, to code more capital. And the example I present in the book is of Lehman Brothers, the investment bank that collapsed in the 2008 crisis. Lehman Brothers had hundreds, if not thousands, of subsidiaries, many of them in the same jurisdiction, the same state or country, 60 in Delaware, 34 in England, 34 in the Cayman Islands, some in France, some in Germany. And the question is then, why do they do this? Because they have an integrated global business and they use the corporate form to organize it. What the corporate form does is what I call durability, one of the key attributes of the Code of Capital, because it subdivides the assets of a business entity into different legal categories. Each of them is a separate legal entity, a separate legal person that owns its own asset. And in doing so, you can protect a group of assets, a pool of asset, from the creditors of another pool of asset. Right? So by just subdividing all these different assets and interests into different legal entities, you're creating legal walls that can't be breached in principle between one and the other. And so you're exposing creditors to the risk that if they can't get the money from one subsidiary, that's the end of the story. Unless the parent company comes in and says, actually, we might want to guarantee the assets of this entity in order to lower the cost of credit. But then the question, of course, is the parent company, what are the assets that the parent company has? And the parent company typically has only the shares in many of the subsidiaries. What I'm saying is basically we can create a kind of a house of cards by creating the illusion of a single big business entity which is organized in many different legal forms, all different corporate entities, that play a game to raise capital on the cheap, but are backed only by the assets that the parent company has and these entities that just raised a lot of debt for financing itself. So what I'm saying, it's not just the company, it's not the enterprise, but it's the legal form that we have invented, the corporation, which creates a separate legal entity that can own its own assets, contract in its own name, can sue and be sued in its own name, has its own governance structure, its own management. And by multiplying these entities, we can play a game of hide and seek from the tax authorities, from other creditors as well.
Mais vous pourriez développer ce qu'il y a vraiment d'ingénieux dans la création de l'entreprise?
Yeah, so when you go back in time, it's always interesting to have historical examples, right? Back in time when merchants decided that they wanted to pool their assets together and to go out and do a business venture, because sometimes you can make greater returns. If you pool your assets, you make returns, then you come back and you divide the spoils amongst yourselves. So the early trading companies were designed to allow the merchants to pool their assets. They would do something together, they came back, they would divide everything, and they would dissolve the company. That was it. So the next step was to create companies that would have a longer lifeline. They would basically be created for 20, 25 years. They could be reincorporated afterwards. But there was still a risk that the shareholders who would put in assets, capital or goods, would pull these assets out, and then the company would collapse, right? So at some point in the early 17th century, a decision was made that the shareholders could not take out their money from these companies. Once you make a contribution, you make a contribution. What you get in return, you get a share in the company and you can trade this share. That creates durability for the company because with a firm capital base, it can survive even if the shareholders change, right? But the shareholders could not take out the money again. That's basically shareholder lock-in. That's one of the key functions of the corporation. Another one, and that's again sort of in order to get shareholders to put their money in the company, which they can't take out again, right? And they might be able to trade it, but that of course is a risky undertaking. So you lower the risk for shareholders, and you do this by saying, you may lose what you put in, but you will never lose more. So in contrast to a simple partnership, if we don't use a corporation, we do a business, the debtors don't find enough money in the company when it goes under They could come and take your family home. They can take your family silver. They can take your shirts, everything. But if you're a shareholder in a corporation, they cannot, because the corporation gives shareholders the privilege of limited liability, which basically means you put your money in, you might lose it, but you will never have to pay more, even if the company goes down.
Oui, donc en fait, finalement, l'entreprise, c'est aussi une façon de ne pas payer ses dettes si le business tourne mal, finalement.
Yes, of course, and the organizers of companies have learned how to play that game. So if you have a risky, especially risky undertaking, you don't keep this in the big company. You create a separate legal entity, a subsidiary, and you run the business there. Think about the big, let's say, asbestos cases or tobacco litigation cases, or if you already fear legal liability, you better push these assets into a subsidiary. If then the tort claims mount or claims against that entity mount, you simply let it go into bankruptcy. End of story. You can protect the mothership, but you allow the subsidiary to go under, and basically the creditors bear the cost of this undertaking.
Mais finalement, si on parle d'objectifs, quelles sont les stratégies de codage les plus utilisées? Dans quel but ils font ça principalement?
Yeah, durability is the key word here, and the legal coding devices, the modules that are used most often to create durability, which means we want to separate assets from other pools of assets. We want to protect them against too many creditors, including the state, right? The state, through its taxing authorities, is very often the largest creditor of all. 30%, 20%, right? There are few creditors that have claims in this amount. So if you protect your assets against the state, against taxation, you already have a comparative advantage over others. So what we do is we use usually the common law trust or the corporation, which are devices to create legal shields around pools of assets. We're transferring some of our assets to a trust, which is it's a vessel. It's an empty legal vessel that is managed by an appointed agent, could be a bank, could be somebody who's a trustee, and manage this on behalf of a beneficiary, but separates it legally from the assets that you own. So if you put some of your money into a trust, let's say in the Cayman Islands or in Jersey or so, you can claim to the tax authorities that this is not your money, because this money is held by a trustee on behalf of a beneficiary. Right, and so the question is, of course, then who's the beneficiary and whether he's taxable, but that makes this thing much more complicated. But the idea is to create these different legal entities. Same when you create a corporate entity in the Cayman Island or in the known tax paradises. You have hundreds and hundreds and hundreds of corporate entities registered in the tax paradises, which are managed typically by the same slate of board of directors, because they just use the same people to do this. The only purpose of these legal entities is to create vessels, legal vessels, in which people can pour their money and their assets to hide them from the tax authorities.
Alors, on peut voir justement les effets du lobbying et de la concurrence aussi des paradis fiscaux avec ce graphique qui montre aux États-Unis l'évolution du taux de taxation effectif, réel, sur l'impôt sur les sociétés, donc, qui était à presque 50% au sortir de la guerre. Bon, il reste encore quelques pourcents aujourd'hui, mais on se demande si ça ne va pas arriver à zéro. Qu'est-ce que vous en pensez? Est-ce que c'est une illustration justement des effets du code du capital?
Yeah, you may want to ask the question, why would the state actually lower the tax rate again? Once you have it, why would you ever lower it again? And I think the reason is that the state cannot enforce its taxes effectively. And why is that? I think this can again be explained through the law. Because the state recognizes that when you set up a company, a corporation in the Cayman Island, that this is a separate entity. Wouldn't have to do this, but we do this. We recognize an entity that is created under a foreign jurisdiction. We all know that the only purpose of this entity is to shift assets to it so that it can be protected. These assets can be protected from the tax authorities. But if we allow this to happen, or if we allow companies to go overseas and produce overseas, but say, as the US does, we will not tax you unless you bring the money back to the United States. You basically create a comparative advantage for these companies overseas, but at the same time also give them incentives to do precisely this so that you don't have to pay taxes at home. In that game, the better people become at trying to evade taxes, the more people will join that game, or I should say avoid taxes, because it is legal. It's done in a way that it's sort of formally legal. The more people do this, and you can get a comparative advantage, you become rich by not paying taxes, the harder it becomes for the state to enforce its taxes, because everybody's doing that. And so it's starting to lower the rates to make sure that maybe enough people stay in the United States and don't try to shift their assets somewhere else. In order to capture these taxes. And so I think this is a competitive drive towards a tax rate that effectively is not zero, but it's much, much less than it used to be before. And the reason for that, I think, is the sophisticated use of legal coding techniques, in particular the use of corporations in other jurisdictions.
Vous expliquez finalement que les plus riches doivent leur fortune non pas tant à leurs efforts et leur travail qu'à une bonne utilisation de la loi finalement. Donc est-ce que ça décrédibilise pas un peu le discours qu'on entend souvent sur la méritocratie des plus riches, c'est normal, ils ont du talent, etc., etc.
Yeah, I don't want to deny that some people have better skills and that they're just very smart in doing certain things, or they might just have an intuition for finding the right time when they sell their assets or buy new ones. That, of course, is all true. But the point that I want to make is when you think about the amount of wealth that has been accumulated, when you think again about the trunk of the elephant in the elephant curve, this amount of wealth could not be created without corporations, without trusts, without being able to evade taxes, without protecting your assets and making them durable over time. They need the law in order to incubate, in order to accumulate that kind of level of wealth. And so they're using a social resource, the legal system, to create riches which they otherwise would not be able to create.
En fait, vous montrez finalement le système, il n'est pas si libéral que ça, et vous donnez d'ailleurs un peu l'exemple de la fameuse main invisible d'Adam Smith en expliquant qu'il y a surtout une main qui guide la loi.
Yeah, I mean, what is interesting in Adam Smith, when you read the couple of pages around the invisible hand metaphor, he actually explains that the invisible hand works because the merchants that venture overseas, that go somewhere else, they will always come home, where they will necessarily share some of their riches, some of their gains with their fellow citizens. But why do they come home? And Adam Smith says they do come home because that's where they know the institutions. That's where they know the law, essentially. Now, in our new global system, we have essentially created legal protections that make it less necessary, less important for people to come home. On the contrary, very often they're much better off in using foreign law. They might stay home, but they use foreign law to create their interests. So I think the invisible hand of Adam Smith is very often misunderstood, and it's also misunderstood that he himself realized how important institutions are for the invisible hand to work. We have used this metaphor to create a system that makes it so easy for most to stay elsewhere and not to come home. And I think we have made the invisible hand therefore ineffective.
Finalement, si je reprends votre exemple tout à l'heure du football, c'est sûr que c'est plus simple, il y a une main invisible qui change les règles du match en cours de match, en fait.
Yeah, well, it's not that invisible, right? It's the lawyers on the side of the players who change the rules, yes, but that's how it works.
En fait, ce point est très important parce que les gens sont plutôt légalistes, donc dans leur esprit, voilà, la loi, c'est quelque chose de très important. C'est ce que vous appelez l'argument qui est souvent mis en avant par les codeurs de capital, puisqu'ils viennent vous dire ah bah oui, mais attendez, moi ce que je fais, c'est légal. Est-ce que justement, il n'y a pas un problème dans l'esprit des gens entre ce qui relève de la légalité et ce qui relève de l'aspect de la légitimité?
Yes, I think our legal system works because most people believe in the authority of the law. It is basically a system of trust. If we stop believing in the legal institutions, then I think our societies would become much, much harder to govern. They might even fall apart because most of us voluntarily comply with the law because we believe that it's important that we all do that, right? Some breach the law, but most people, most of the time, are compliant with the rules because they believe that this is necessary to keep societies together. Now, if some then use the rules in a highly mechanistic and utilitarian fashion and push the limits of these rules because they don't care about the underlying normative values, what they do care about is pushing the limits to make money, under the disguise very often of efficiency or, and we're talking about efficient breach of contracts even, people basically push the limits of legal rules which they only conceive of as constraints on actions they believe are efficient or beneficial for their clients. And if you see then, if we observe that many people are opting out of your legal system or pushing the limits of your legal system, the question is, why should I play by the rules if nobody else does? If you bend the rules, why should I be bound by them? And that, I think, erodes the trust in the legal system, which is essentially for the rule of law.
Finalement, vous expliquez que le capitalisme moderne ne pourrait pas exister sans ce codage juridique. Pourquoi?
Because without the legal coding, some of the riches that we might gain by chance or skills or good intuition might be dissolved by the next financial crisis or the next economic downturn, right? The key is to be able to protect enough spoils so that you can reinvest once the crisis is over and we have better chances again. And so without the legal coding, the amount of riches that you have, you just would not exist, and you could not expand them over time.
J'aimerais vous demander si, à votre avis, la mondialisation aurait pu avoir lieu sans toutes ces modifications juridiques?
Globalization, in my mind, is actually a legal project. Because globalization means that we can do transactions across different jurisdictions. So think about a contract between you and me. I live in the United States, I'm German, you're French, we enter into a contract over something, maybe a car. What law governs this contract? So if I don't deliver my car, are you suing me under French law, under American law, under German law? We have to sort of decide that. Once I allow the private parties to choose the law, so we decide we don't trust French law, we don't trust American law, maybe we take Swiss law, just the third country, right, for our contracts, then I can opt out of these legal systems. I can do transnational transactions more easily by choosing, let's say, a different legal system. And if you have a dispute, we don't go to a court, maybe we go to arbitration. And then luckily we find that there is an international convention that says that the arbitration awards that a private arbitration tribunal makes can be enforced in a court of law in a country where you can find assets. So globalization is not a law-free space. It's also not a state-free space. Globalization is a space where people find the legal system and the legal rules that are most attractive to them. They pick and choose from different legal systems to code their interest in law and make them enforceable in law. And then they will lobby different countries to ensure that even if they get a ruling somewhere else, or even if they have the right under a different legal system, it will still be enforceable under domestic law.
Vous expliquez qu'en fait, un empire du droit s'est finalement répandu sur la planète et que contrairement aux empires précédents, il n'a pas besoin d'armée. Mais de quoi a besoin cet empire alors pour exister et comment il s'est constitué?
It needs legal rules and it needs the commitment of different states around the globe to enforce interests, even if they are coded not in their own law, but in foreign law. So there's a body of law that people don't really know much about if they're not lawyers, which is called international private law in Europe or conflict of law rules in the United States, which are part of the domestic legal orders. And they determine which law shall be applicable if more than one is in play. So if people transact from different countries or if you create a subsidiary in a different jurisdiction, which law shall govern? And if that subsidiary, that entity does then business in the home country, will they recognize it as a legal person? Will they recognize it as a company with limited liability? These are important questions that have to be resolved. And for a long time, for example, both Germany and France and other countries said, actually, if you do your business here at home, let's say in Germany, and you're not incorporated as a German company, then we will not recognize you as a corporation. You can't just go to England and shop for a better law, but do all your headquarter business in Germany, we will not recognize you. The European Court of Justice said at some point, no, you can't do this because it violates the principle of the free movement of legal persons and the free movement of capital. And of course, what is moving is not the enterprise. What is moving is the law, right? So you still do business in Germany, let's say, today, but you can choose the laws of another European country at the very least. Now, after Brexit, it might not be England, but it could be the Netherlands, or it could be Luxembourg, or it could be another jurisdiction like that. So essentially, once you can pick and choose, like from a menu in a restaurant, the law that best suits your interest, then you can also put together a private legal regime that will be respected by states and will be enforced by the courts of this state, almost wherever you go.
Est-ce que le droit de l'Union européenne a été finalement complice dans ce développement du codage du capital?
Well, the European Union was, of course, founded as sort of an economic union. But in the beginning, there was sort of an implicit agreement amongst the member states, including the European Court of Justice, that harmonization should precede the opening of all borders. So the idea was that we basically create a similar level playing field for everybody, and then we open borders. In the 1990s, also with a change of discourse about neoliberalism and efficiency, etc., the European Court of Justice eventually ruled that there has been enough time has been passed for the countries to get together and harmonize the law, and they haven't been able to quite do it. And they would now enforce the principles of the treaties. And these principles were enshrined already in the Treaty of Rome, which basically says free movement of capital, free movement of services, free movement of people or persons, which are natural persons and legal persons, and thus include the corporation. And in particular, the free movement of capital was endorsed in the 1990s. And that has led to a series of court decisions by the European Court of Justice, which basically says, yes, you can pick and choose. The law and the countries cannot stop you from doing that.
Justement, à propos de cette liberté de circulation, vous faites une métaphore entre le capital et les bandits, puisque certains peuvent être stationnaires ou vagabonds. Vous pouvez nous expliquer?
Yeah, I'm actually borrowing this metaphor from economists who have labeled the state as a vagabond or like as a bandit. And they basically say in the beginning, before we had established states, they were very often roving bandits. So the bandits would just run around and then grab all the assets from people that they could get, and the people would starve, and they would have to go somewhere else and find more resources. At some point, they figured out that it would be more efficient for them to be stationary bandits, basically to settle, and then, yes, to exploit the people, but only just to that level that they could survive, right? And that made the states more stable. I'm using the same metaphor to talk about capitalists and say, our global capitalists today are roving bandits because they can actually roam the globe and grab assets, and the state backs that because the state makes it possible for them to pick and choose different legal systems, move around to different jurisdictions, all do this under the mantle of legality, and enforce their rights as they please. So we have created or made legal the possibility for roving bandits to be quite effective and to move around and find new resources all the time for themselves.
Cette espèce de shopping juridique que vous dénoncez, est-ce qu'il est possible finalement parce qu'il y a un dumping juridique aussi mondial? Je pense à l'exemple que vous développez sur le Delaware, ce petit État ridiculement petit aux États-Unis, mais qui abrite 66% des sièges sociaux des 500 plus grandes entreprises américaines. 80% des introductions en bourse se font avec une entreprise qui est au Delaware, parce que c'est une espèce de paradis fiscal américain. Donc, qu'en est-il de ce dumping juridique?
Yeah, the beauty of being able to shop for different legal system is that you can find the one that best suits your interest. And in the United States, the small little state of Delaware, which used to be an agricultural state, became most attractive for corporations already in the late 19th and early 20th century. Of course, most companies were located in New Jersey or New York. These were the industrializing centers in the United States, right? But Delaware was able to pass the law that was most attractive to these companies. Why? Because Delaware didn't have any labor unions. Delaware didn't have any interest that would oppose the interest of managers and shareholders in effect. And so when we talk about dumping, we could say we can avoid political and legal constraints of other jurisdictions by picking and choosing the jurisdiction that best suits our needs, and Delaware is a very good example of that.
Mais finalement, on voit qu'avec ce shopping juridique, c'est possible d'aller empocher des gains partout et puis de laisser les pertes et les problèmes dans chaque pays sans en être responsable.
Yes, in principle. I mean, countries can protect themselves a little bit. So if you shop for corporate law, you don't necessarily also shop for financial regulation. So there are different areas of the law where states can still impose some constraints. But I think nonetheless, it's fair to say that the ability to pick and choose one's laws and legal regimes, especially if you have good lawyers who can understand how to put these different legal regimes together to get the best outcome, imposes or shifts the losses or the risks associated with business to society at large, and keeps the gains for the capitalist.
Mais finalement, il y a combien de systèmes juridiques comme ça qui existent pour coder le capital?
One might think that if you give people the option to choose from different legal systems, you would get a patchwork, sort of like let 100 flowers bloom kind of patchwork of legal systems. But this is not the case. When you look at how the most widely traded financial assets in our system of global capitalism, financial capitalism, are coded, then you come essentially to two jurisdictions only. You come to New York, that is American law, and you come to English law. And you can also explain this both historically. These are important trading centers, they're important financial centers. There are the largest financial centers in the world still, but they're also, and that's critical for my point, they also are the places where the biggest global law firms are located. And global law firms are firms that have offices in more than one country. Of the 100 largest global law firms, at least 90 or so are from the United States, and the rest is almost exclusively from Great Britain. There's now a Chinese company, which is, however, also a merger of an American and a Chinese company. So the largest global law firms that code most of the globally traded assets are mostly Anglo-Saxon law firms.
On a vu finalement que pour exister, ce codage du capital nécessite un État. Mais comment il peut y avoir une globalisation puisqu'il n'y a pas d'État mondial, mais une multitude d'États?
Well, the multiplicity of states and legal systems is actually beneficial for capital. So people very often think globalization needs a global law, needs a global state, but it's actually much more advantageous if those who know how to do this can pick and choose the law by which they want to have their affairs governed, and still have a commitment, a guarantee by most states that they will enforce these coding devices. So it is really a private regime. It gives private parties the option to use the law and pick the law by which they wish to be governed.
Finalement, on voit que ce shopping juridique, ça rend les États beaucoup moins puissants, mais ce shopping n'est possible que parce que les États l'acceptent, finalement. Comment ça se fait que les États aient accepté? Est-ce que les États sont devenus fantoches, finalement? Est-ce qu'ils sont soumis à cette puissance? Est-ce qu'ils sont complices?
You could say they're complicit, but you could also say that for the states, it's actually beneficial to have transnational trade and investment, right? So many states believe that they have to attract investors from the outside. So they have to make it attractive for them to come, which very often includes allowing them to choose a different legal system even if they do business here, or at least to repatriate their profits. So there is a manifest state interest also in creating a legal system that allows some to become rich, because it also helps to grow the economy, even if it has massive distributional consequences within that state. So I think it would probably be too simple to say they're just captured by the capitalists or they're just explicitly complicit. But I think there is sort of a confluence of interest of state actors and private actors that has created the system, and the state has been actively involved in basically breaking down the boundaries of state borders in order to make transnational and global trade and investment possible.
Est-ce qu'en fait les États croyaient vraiment qu'il y aurait cette espèce de ruissellement des plus riches vers les plus pauvres?
Yes, I think that's the underlying philosophy. So we all benefit when when more wealth is being created in our society. Somehow everybody will eventually participate in that. I'm not sure this is entirely true. Maybe in the very long term, but only with explicit state intervention that makes sure that we have distribution in favor of those who make less money. But that kind of redistribution becomes less likely the more options the rich have to opt out and opt in into different legal systems. So I'm a little bit more pessimistic that this system of trickle-down economics works, and I don't think the data bears this out that it does.
En fait, on peut voir assez bien quel ruissellement il y a eu. Enfin, c'est un ruissellement plutôt du bas vers le haut, puisqu'on voit sur ce graphique l'évolution des revenus des 10% les plus riches en haut et des 1% les plus riches aux États-Unis entre 1850 et 2021. Donc, on voit que les 10% les plus riches, ils approchent les 50% des revenus, les 1% les plus riches, 20% des revenus. Donc, on voit que le ruissellement ne s'est pas passé suivant les règles habituelles de la gravité, en fait.
Yes, well, I think this is, you can explain sort of basically the violation of the laws of physics, of gravity, by legal coding devices. It's basically an artificial creation. You're creating the conditions through law that allows those who have better resources to use more of the legal system to protect themselves and to create new types of assets that generate that generate wealth for them.
Alors, il y a quelque chose qui est assez peu connu des gens et qui a été développé en particulier dans les traités d'investissement bilatéraux, donc entre les États. C'est un système d'arbitrage qui permet finalement aux entreprises maintenant d'attaquer les États si elles considèrent que des législations portent atteinte à leurs intérêts. Ça s'appelle l'ISDS. Est-ce que vous pouvez nous expliquer ce que c'est ?
Yeah, this is the investor-state dispute settlement system, which is part of many of the bilateral investment treaties that states have entered into with one another. Now, let me just first say this is another wonderful example about how deeply states are involved in creating new types of property rights. Because for a foreign investor to be able to take the sovereign state of a country it invests into an arbitration tribunal outside that territory, to enforce his rights as an investor and get expropriation-type damages, you need a legal structure that gives you these rights. It doesn't exist without it. And these legal structures have been created. The first investment treaties date back to the 1950s in the 20th century, but the most important innovation in the investment treaties was done first in the North American Free Trade Agreement in 1994, which included these investor-state dispute settlement. So here's the irony. In international law, only sovereign states are subject of international law. Private entities are not subjects. They don't have rights. I mean, they don't have rights against the states except for, let's say, human rights, that we create also a certain type of legal regime for them. But we have created a system for foreign entities if they invest in a country and the state infringes, whatever this means, infringes their investment, they can sue for damages either because they have been expropriated or they have been treated in an unfair and inequitable fashion. These provisions, which are found in thousands of bilateral investment treaties, have been used by investors to protect their investments, you could say in the most beneficial way, but you could also say they have been used to stop states in their track when they try to regulate what happened in their own countries. And so you create a new type of property rights regime that potentially can cost states millions of dollars if foreign investors come and say, we will sue you because you passed a new law that infringes my investment and I now can sue for damages.
Alors, on peut illustrer ce qui s'est passé parce qu'il y a eu un très fort développement de ces contentieux qui relèvent de l'arbitrage, qui ne relèvent pas de tribunaux constitués, mais d'arbitres privés. On est à peu près 1230 aujourd'hui, depuis l'origine. Et on voit qu'au niveau des décisions, dans à peu près 40% des cas, bon, ça va, l'État a gagné, mais dans 30%, c'est l'investisseur qui gagne. Dans 20%, il y a un accord entre l'État et l'investisseur, donc comme ça coûte à l'État, donc c'est assez scandaleux, parce que finalement c'est le contribuable finalement qui paye. Et pour bien situer ce dont on parle, dans les cas qui ont été jugés, en moyenne, la condamnation de l'État a été de 520 millions de dollars. La France est concernée, elle vient d'avoir son premier cas avec un contentieux de 4 milliards, puisque l'État avait pris une mesure de protection de l'environnement, pas voulu faire une mine, et donc les compagnies minières attaquent l'État en disant vous ne voulez pas que je fasse ma mine, vous me donnez 4 milliards maintenant, on verra combien ils obtiendront. Ça pose un vrai problème finalement, ce choix d'arbitrage et ce choix de procédure.
Yeah, I mean, the key of these investor-state dispute settlement mechanism is that you do not have to go to the courts of the country in which you invest. When you claim that some new legal rules or some measures taken by the state have expropriated you or have treated you unfairly, you do not have to go to a French court, but you go straight to a tribunal outside that state. That is really important to understand. And that allows investors, of course, to threaten, even just to threaten that they will bring a country to court, to an arbitration tribunal, and they might therefore settle before anything is ever being decided. The amounts that they can extract are quite exorbitant. I mean, they can get a lot of damages, and it's of course of concern for countries that want to take measures in the interest of their own people, because they now have, through these treaty mechanisms, they have bound their hands that they might have to pay up to investors if they take measures that violate their interests. And I think most dramatically, of course, now in the age of climate change with mining companies. So there are these bilateral investment treaties. There are also some multilateral treaties like the Energy Charter Treaty. And France, in addition to Spain and the Netherlands, have recently decided that they would terminate their membership in these treaties because under the treaties, many of the brown companies, the natural resource companies, have begun to sue democratic states that have decided we want to phase out coal, we want to phase out oil, we want to make sure that we survive the climate crisis. They have made it effectively much more expensive for countries to do so because they have to pay damages to investors that say, well, we have invested and we had the expectation that we could always make money on coal or oil or other natural resources in your country. And since this can go to arbitration elsewhere, now, of course, the state could say, we don't pay up. The state could always say, we just don't pay damages. The implicit threat is that this will cost you a lot of foreign investment. So most states that have been sued under the ISDS provisions have paid up if they were held liable to investors. Only very few have tried to escape that fate.
Oui, donc qu'on comprenne bien, hein, c'est bien une justice avec des arbitres, donc ce n'est pas des juges professionnels, hein, c'est des juristes privés qui décident de ça, sans appel. C'est exactement ce qu'il y a eu, un scandale en France avec l'affaire Tapi du Crédit Lyonnais, où il y avait eu un arbitrage complètement bidon qui avait été annulé au final. Donc j'ai envie de demander encore finalement pourquoi les États acceptent cette situation, acceptent de se voir condamnés simplement parce qu'ils votent des lois. Pourquoi cette soumission librement consentie?
Well, states are made to believe that it's in the benefit it's for the benefit and in the interest of the state. And I should add to that in the 1990s, an attempt was made to create a multilateral investment treaty because the global north, France, Germany, the United States, England, wanted this because they felt they had to protect their companies, European companies or North American companies who invested in emerging markets or developing countries from the threat of expropriation. They never thought about the fact that companies from somewhere else could come to their jurisdictions or that some companies could start legal shopping, again, forum shopping. So if you want to sue France, you can't be a French company under this mechanism. But if you reincorporate a subsidiary in the Netherlands or in Norway or in somewhere else, you can come as a foreign investor and claim that you now have an interest against France, and you can use this mechanism to enforce it. So I think when the states signed up for this, the global north thought, oh, that we need this to protect our companies in the global south. Then we had a much more complicated mechanism, and I think now it's coming back, and many countries are starting to change the treaty language of their bilateral investment treaties. The problem is that the treaties have typically a length or a duration of 10 years and very often grandfather the rights that they have created for another 10 years under the language of those treaties.
Alors vous expliquez aussi que pour beaucoup d'entreprises, aujourd'hui, ce qui compte, ce n'est pas tant ce qu'elles possèdent en termes de biens, mais plutôt ce qu'elles possèdent en termes de propriété juridique, en particulier les droits de propriété intellectuelle. Est-ce que vous pouvez nous expliquer finalement ce qu'est un brevet, comment ça s'obtient?
A patent is a right that has to be granted by the state to exist. Right? Because in principle, we have ideas which can be widely shared, or we have innovations that can be copied by others. But states have found it in their own interest, in the interest of companies that reside in those states, to create artificial property rights. And one of these kind of rights is a patent, which gives an innovator or the company that files for the patent on behalf of an innovator, the right for a period of time, 20 years or so, to have a monopoly over this particular innovation, this particular idea, and to therefore also capture most of the economic gains of this particular innovation. So I think it's even a better example than land to show that property rights exist in law. They don't exist outside the law, they are being created in law.
Alors vous expliquez justement, en l'illustrant, à quel point la course au brevet peut être problématique. Et justement, on retrouve de façon assez éloquente l'exemple de Pfizer, donc la compagnie pharmaceutique qui, déjà dans les années 70, œuvrait beaucoup sur cette problématique des brevets. Vous pouvez nous expliquer ce qui s'est passé?
Yes, I think companies in the global north realized increasingly since the 1970s that one of their most valuable assets were patents. But patents are created by state law. So if they have a patent in the United States, companies elsewhere might still produce the same pharmacies and use the ideas, and they can't do much against it. So they lobbied increasingly, first the US government, to lobby for an international agreement that intellectual property rights would be protected everywhere. Now, some countries, in particular India, have made a decision that they did not want these kind of rights. Actually, a debate that we had in the 19th century as well. The Netherlands in the late 19th century abolished patent rights again because they wanted to make sure that everybody can share knowledge and everybody can use this knowledge to create a new firm and do something else. And the big irony, I think, of our time is that in 1994, when we created the World Trade Organization, which is for open trade, the next thing that happened was TRIPS, which was an international treaty built into the WTO framework to say we want to protect property rights or patents, which is another way of saying we want to create monopolies, which is the opposite to free trade. And behind that movement were very well organized business interests in the United States who also got their European counterparts on board to lobby their governments to create this international treaty to ensure that the companies that already had property rights created in their own domestic legal systems could effectively expand them to other legal regimes, to India, to Mexico. And so they sometimes forced this. I mean, they put pressure on the US government, and the US government in particular used sometimes trade sanctions vis-a-vis other countries such as Brazil to push them to agree to these kind of protections in their own countries and to sign up to the TRIPS agreement. At some point, there's, I quote this in my book, one of the industrialists basically said, Mexico gave us all we wanted, which means basically they gave us exactly the kind of property rights that we wanted to have to be able to capture the Mexican market and avoid competition by Mexican firms that could do generic drugs or other things in that market.
C'est finalement un bon exemple où on voit que des pays très riches comme les États-Unis eh bien, deviennent encore plus riches en ayant à extraire de la richesse sur des pays en développement comme le Mexique.
Exactly. I think what they do is they use the mantle of legality to appropriate resources from developing countries. And there's wonderful cases in India where they use basically herbs that have been used for centuries to heal people. They create a patent over it and then are trying to force people in India to pay license fees to US companies.
Vous développez tout ceci dans un chapitre qui s'appelle le codage de la nature, et qui est celui qui m'a le plus impressionné, parce que les conséquences sont quand même extrêmement fortes et dommageables sur les gens. Et donc à l'intérieur, vous expliquez ce qui s'est vraiment passé dans un exemple qu'on a entendu parler en 2013, quand l'actrice Angelina Jolie a expliqué qu'elle avait subi une double mastectomie parce qu'elle avait fait un test qui montrait qu'elle était porteuse d'un gène qui s'appelle le BRCA1, qui lui donnait 90% de chances de développer un cancer. Et surtout, elle a expliqué dedans, dans une tribune qu'elle avait rendue publique dans le New York Times, qu'en fait, ce test lui avait coûté $3 000 et que c'était un problème parce que plein de femmes ne pouvaient pas avoir accès à ce test et donc avaient une énorme perte de chance et donc allaient développer des cancers sans avoir pu réagir. En fait, vous expliquez derrière l'histoire qui est complètement hallucinante sur ce qui s'est passé autour de ce gène et pourquoi ça coûte $3 000.
Yeah, this is again to be explained by the law, right? Because many doctors actually had already created some test kits to identify the gene defect. And they were able to do this in part because there had first been an international consortium of scientists that were mostly funded by public money that had identified the gene that is responsible for this particular aggressive form of breast cancer and had published their results in scientific journals. So this is now public knowledge. Everybody can have it. But in order to be very effective in identifying the defect in women that want to undergo these kind of tests, you need to have the sequence of the gene. You need to know exactly how the different elements line up and where the defect might be. And so there was, again, an international consortium funded by public money, but there was also a small company, Myriad company in Utah, that used venture capital funding to try to be first in identifying the sequence of the gene. Myriad company was a little faster. They ran to the US Patent Office and they claimed that they had a right to a patent. Now, here was a state act that shouldn't have been given but was given, and in part because there had been earlier case law by the US Supreme Court that said, yes, we understand that in principle the genome shall not be patentable because it's one of these things that belong to humankind. It's available for everybody. But if humans manipulate this, if there's human ingenuity involved, the US Supreme Court has often said, then we patent it, because they want to basically create an economic basis for creating wealth. And the Patent Office granted a patent to this particular sequence, on the basis of which the Myriad company was able to go back to hospitals and doctors and say, you cannot use their own test kits. We now basically own the sequence of the gene. You have to buy our kit, which also means you have to share the data, the information that you get from all these women that you're testing with us. Doctors and patients rebelled against this and they started litigating. It took them quite some time. It took them until 2013. I think the patent was granted in the early 1990s. It took them until 2013 to finally win in the US Supreme Court. So I think, again, a positive story here, because the US Supreme Court said, you know, most of the patent covered something where there was no human ingenuity other than discovery. There was not actually active manipulation or active innovation involved. And so the genome should be available for everybody. So they struck down the patent, but until then, Myriad Company had made a lot of money, and many other tests had never been developed. There was no competition, right? You create a monopoly, which also has opportunity costs that are very often ignored in these debates.
Bon, on pourrait dire, bon, bah, c'est bien, au moins ça n'a pas marché pour le brevet. Mais d'ailleurs, même si ça avait marché pour le brevet, bon, ça n'aurait pas été très juste, mais un brevet, ça a une durée de vie limitée, donc au bout d'un moment, ça s'arrête. En fait, il y a quelque chose d'encore plus grave, et c'est fou dans cette histoire, c'est que ça ne s'est pas du tout arrêté au brevet, c'est qu'on est passé cette fois au secret des affaires. Et vous expliquez, c'est un gros problème quand on est à l'heure du big data.
Yeah, one would have thought that after the US Supreme Court struck down the patent, Myriad Company would have had some financial losses, but they did not. And the reason for that is that they had created this massive database, because all the tests that were done on women for about 20 years for this breast cancer gene were shared with Myriad Company, because it had a monopoly over the kit and forced, therefore, doctors and hospitals to share the data. And in the early 2000s, it stopped sharing the database with others. It basically privatized the database and used trade secrecy law to do so. Now, background to this, again, is that the United States was lobbied by big tech companies in the early 2000s to strengthen the trade secrecy law and to basically allow them to protect whatever they can protect by their own means, technologically or otherwise, is theirs, and others who try to breach that and get in and get access to this information are hackers and can be therefore sanctioned by criminal acts. This is like a little bit going back to the Black Act. It's not quite capital punishment, but if you take the data from somebody who claims it to have, you know, organized them for themselves, this is like treated like theft.
C'est-à-dire qu'on soit bien d'accord, c'est avec ce secret des affaires aussi, ils ont décidé d'arrêter de partager les informations, ce qu'ils avaient appris sur le cancer du sein auprès de la communauté scientifique mondiale. Donc c'est un vrai problème aussi pour aider la recherche contre le cancer.
Yes, that's what monopolies do, right? Very often it's said that patents are needed so people do innovate, but at the same time, patents exclude the competition. It also exclude new scientific research that could be done if the knowledge was more widely available and accessible to others.
Votre conclusion de ce chapitre est assez forte, en tout cas elle m'a fait une forte impression, parce qu'en effet elle permet de relier deux choses. C'est que tout à l'heure on parlait d'un point d'histoire, on se dit il y a quelques siècles, il y a des gens se sont dit ah bah tiens il y a un bout de terrain qui était public, ouais non laisse finalement c'est à moi vieux. Et on se rend compte qu'en fait il y a des compagnies qui aujourd'hui font ce que vous appelez une seconde enclosure. Elles sont en train de dire « Oh tiens, il y a un gène là qui traîne, il est à personne, laisse, je vais le prendre ». Et vous avez une jolie phrase que j'aimerais citer qui explique que nous sommes menacés de perdre l'accès à nos données et au code de la nature uniquement pour donner à une poignée de propriétaires d'actifs une nouvelle occasion d'accroître leur richesse au détriment des autres. La seconde enclosure, celle de la connaissance et non de la terre cette fois-ci, est plus silencieuse que la première car elle se déroule sans violence physique. Donc on voit qu'il y a un grave problème. Quelle est votre vision? Quelles sont vos craintes?
Yeah, we're seeing actually the same pattern all over again, right? We saw this with the enclosure of land in the 16th century in England when it wasn't actually clear who had the better rights to the land. And the landlords won because they made a very forceful argument that somehow they had seniority, but also that their interests were worth more for society than those of the others. And we're doing the same again now with patents. And by creating patents for some in the hope that somehow they create something again in the trickle-down mentality that create something everybody will benefit from, we are in fact making it impossible for many others to use the same kind of information, the same kind of knowledge to create perhaps even more for us. And so I think we are sort of repeating mistakes, and I think it's even worse with patents, because knowledge is non-rivalrous, right? If I take the knowledge, you can still have the same knowledge. You're not taking anything away from me. We can still eat the same cake, essentially, right? And have the same amount of cake, but both of us. And when we sort of create these intellectual property rights, we make it impossible for others to have access to that knowledge.
Oui, parce qu'on voit bien que dans la première enclosure, il se trouvait des gens qui se mettaient à protester en disant mais avant, moi, j'allais prendre mon bois là dans la forêt, je peux plus. Donc, ils se révoltaient, ils criaient. Aujourd'hui, c'est pas le cas. On voit que les gens ne comprennent pas ce qui se passe et on leur dit juste voilà, c'est $3000 le test pour le cancer du sein, tu les as pas, tant pis. Et donc comme ils comprennent pas ça, en fait ils peuvent pas réagir à cette seconde enclosure. Est-ce que vous pensez finalement qu'il faut essayer de mieux informer les gens pour qu'ils puissent justement se révolter et protester?
Yeah, the problem is that most of these coding strategies today are so invisible. It's no longer about the land and about fences and hedges. It's about legal rights that are granted by a patent office, or sometimes are challenged in a court of law, or it's about financial interests that are also coded in the office of big law firms. And most people don't know about this and don't have access to enough information to protest it. And this is one of the reasons I wanted to write this book. I just felt we have to open up the inner workings of the system.
Vous avez un chapitre aussi où vous développez ce qui se passe avec le codage numérique. Finalement, qu'est-ce que l'arrivée des nouvelles technologies change sur ce codage du capital et quelles sont les perspectives, les craintes?
Yeah, so the question I had to ask myself in our age is whether the legal code, which I have followed for centuries or so in the book, whether the legal code might be replaced by the digital code, because the digital code is becoming more and more important. We have now cryptocurrencies, digital currencies. We have smart contracts that use technology to ensure that a contract can be enforced even without a court of law. Right? Because you basically have to open your wallet to the supplier before the transaction can go through. And so I think this will change and is already changing some of the ways in which the world works. But I think one thing is very parallel to the law. If you have access to the code, if you control the code, you can control the outcome. So the new masters of the code are not the lawyers, but are the technologists. And I think we have to watch that space because it's moving very fast and with a capacity to control social life and social relations that is probably surpassing the power of the law.
Dans la conclusion de votre livre, vous expliquez que finalement la vérité, c'est que dans un monde où le capital vagabond, très bien codé, fait face à un public désorganisé et éparpillé dans plusieurs pays, un contrat social n'est tout simplement pas une perspective crédible. Donc, on voit que l'impact est très fort, ça porte vraiment sur la substance de la société. Donc, quelles sont selon vous les solutions, les pistes qu'on aurait pour que les gens puissent reprendre le contrôle sur le code?
Yeah, I was basically responding to a debate that even the Financial Times entered into, which said we need a new social contracts with capital. But how do you do a social contract when some can pick and choose the rules by which they wish to be governed, and all others are stuck basically with a particular legal system because they're not mobile and they don't have the resources to pick and choose the laws by which they wish to be governed. So if you take Alfred Hirschman's famous dictum that we have as members of organizations, we have exit, voice, or loyalty. If you can exit, you can always vote with your feet. Voice means that you have real voice over the affairs of your countries, and we as voters can do this indirectly by voting for representatives, but we don't really have that much power in our individual voices. And if we have neither exit nor voice, we have to be loyal. We basically are stuck in a system that we no longer control. And I think that's a very dangerous position to be in, especially for democracies. And in my view, many of the populist movements that we see are reactions by people against the sense that they have lost control over their own destiny, that they don't have voice. They certainly don't have exit, and so they're stuck in this situation of loyalty, and that I think is politically explosive.
Et donc en conclusion, est-ce que vous avez des pistes comme ça de réforme pour reprendre le pouvoir?
Yeah, so I'm trying to basically expand the space for policymakers for democratic self-governance by saying, for example, we should limit the ability to choose the law by which one wishes to be governed. We can't have democratic self-governance if too many can just opt out of the system quite liberally. We also have to limit the choice of private arbitration and the idea that the states will enforce these awards without checking their substance and making sure that they're in line with their own norms. So I think there are a series of relatively small but strategically placed innovations or changes that I would like to place in order to make it easier for societies to govern themselves and not be governed by capital.
Katharina PISTOR, merci beaucoup pour cet entretien. Je vais vous poser notre question traditionnelle. Qu'est-ce qui, selon vous, est connu de peu de personnes et qui mériterait d'être connu de tous?
Yeah, I just want to stick to the topic of our conversation, the coding of capital. I think most people think that we're stuck with a system to which there are no alternatives, and many politicians also argue that this is a system that we just have to somehow cope with, but we can't really govern it. But I do believe that if you basically open the machine, if you look at the underbelly of the capitalist system, if you look at the legal institutions and devices that are used to create and sustain that system over time, you can find that we have much more agency. Maybe not individuals on their own, but in courts do have agency, regulators have agencies, legislature have agencies, and even individuals can use the law in ways that serve their own interests in a much more productive fashion. So I think one of my goals in life is to make it easier for people to find legal devices that benefit interest beyond profiteering and beyond coding capital.